Cost shifting strategies, I will not try to belabor any of these, and frankly I can't quite work up the enthusiasm for them that my friend Brian Barnes has for the economic loss rule. If you're ever lonely, need somebody to talk to, call up Brian and say, Brian, can you talk to me about the economic loss rule a little bit? He loves talking about it. You can tell he's got a real interest in it. All right, one more definition.
You could read my blog.
Or you could read his blog. You can read his blog, yes. All right, one more definition for us and then we'll get something substantive. All right, what is the definition of 1 million microphones? 1 megaphone. All right, cost shifting. How does it happen? What is it for? What do we want it for? Like most things in the law, cost shifting is something that most parties are in favor of as long as it's going their way. So if we can get the cost shifting just to go our way, then let's do it. There might be times when it's mandatory, such as after a jury verdict and a judgment. You can, prevailing party can petition for taxable costs, whatever those might be in the different jurisdiction you're participating in, and sometimes they might be discretionary. Let's look a little bit at an offer of judgment in North Carolina. These have to be made by a defending party, which we'll see in some other jurisdictions is not always the case. These are made between the parties, not with the participation of the court. They're good for 10 days essentially unless withdrawn. There is a separate method on contract matters, which I won't go into. They don't really pertain to our topics here. With most offers of judgment, it's possible to offer something that the jury cannot always award. And by that, it might be something of a, either in terms of an acknowledgement of some situation or an apology, or some meeting between the parties or discussion about some items that juries can't award. So it's not something that's going to work every time and might even not work most times, but it's always something to keep in mind of, is there something else we can put into, as I like to say, put in to sweeten the pot to make it a little more interesting for the offer to be discussed and maybe accepted, or maybe the offer to be a foundation for settlement discussions between the parties to get the case concluded. South Carolina offer of judgment. Now in South Carolina, offer of judgment can be made by any party. Remember, in North Carolina is just by defendants. South Carolina, we've had a change in the last few years in our rules about offers. So they can be made by plaintiffs or defendants, or third-party defendants for that matter, for any parties. They have to be in writing, and it's got to be filed with the court. Unlike North Carolina, there's no court involvement. There's a fairly specific step-by-step scheme, if you will, that's set forward, and you've got to be pretty closely tied to that scheme and follow that if you're going to make an offer in South Carolina. They've tried to put some more teeth into it. The old offers of judgment in South Carolina were just for the taxable cost, which basically would be filing fees, subpoena fees, court appearance fees, those kind of things, which generally did not add up to a whole lot of money. So an offer that was not accepted didn't carry a lot of teeth if it didn't go forward successfully. Now they basically put what I call an 8% return on it, which in the case of a plaintiff, if you make an offer to settle for X, you go and get a jury verdict that is better than that, then you get 8% interest back from making your offer. It's a little more complicated than that, but that's basically the sequence of it. Likewise, on the defense side, if you make an offer, we will pay X, you get a jury verdict that is less than X, so it's a defense win on their offer, they get an 8% reduction essentially in what they offered. So it's got some teeth to it now, plus the costs and other things that were available before. So the South Carolina rules got a little more teeth to it now and a little more action to it. And it takes a couple of times walking through the statute a little bit to get comfortable with how the sequence works and where the advantages or disadvantages, exposures weigh out. But it's very much something worth looking at in South Carolina, whereas previously an offer of judgment in South Carolina was mostly just paper pushing. Let's look on to Florida then for a minute. Florida has a very detailed offer of judgment statute. It's got to be complied with very strictly. An offer in South Carolina is on a 30-day window. Whereas in South Carolina, an offer of judgment is on a 20-day window. In North Carolina, as I mentioned before, it's on a 10-day window. So you think offer of judgment is pretty much the same thing everywhere. It turns out that it's pretty much not the same thing everywhere. You've got to follow some strict time frame deadlines in Florida, and the only times that the offers get filed in Florida and become part of the record would be if there's an issue about enforcing the offer or enforcing the terms of the offer, depending on how the award comes out. The last thing I want to say on cost shifting is something other than what my teenagers think of cost shifting, which is from dad to them, pictured by this picture here. There are some express statutes or contractual situations where there can be cost shifting. Those are generally upheld. In the federal court system, there's been some rulings that by the U.S. Supreme Court and statutes that if expressly stated in the statutes that things like expert witness fees can be taxable costs, and it can be cost shifting along those process as well. So it's something to keep in mind depending on where your case is filed and what the claims are. I did want to speak a little bit to some of the environmental statutes, whether it's the Clean Air Act, Clean Water Act, Endangered Species Act, RCRA and CERCLA. Certainly these kind of statutes all have an occasion for the court to do some specific cost shifting, significant cost shifting in a situation where they deem it appropriate. It's generally, in my opinion, a fairly factual determination by the court, but in some ways it's really pretty simple. If the plaintiffs prevail significantly, then a lot of times part of that prevailing is going to result in a cost shifting of the costs to bring the action to the plaintiffs. They're going to get paid for those. The court does have some discretion in other situations, but in these type of citizen suits, that's a part of the big exposure that defendants or insurance companies would need to look at when they're defending these.